The doctrine of severability. The word severability has its genesis from the Latin word salvatorius. It refers to a provision in a law which stipulates that in the event that parts of the law are found to be illegal or otherwise unenforceable, then the remainder of the law should still apply. As the word suggests, it seeks to salvage the rest of the legal provisions, although certain other terms of the same law are found to be unenforceable. Therefore, the court will need to look at the law itself to see whether such a provision does exist, which would then allow the court to excise the offending provisions so that the rest of the law continue to operate. The doctrine of severability owes its origin to the law of contracts, which has been defined as, if parts of the contract are held to be illegal or otherwise unenforceable, the remainder of the contract should still apply. The primary purpose of the doctrine of severability is to separate that portion in a document deemed to be void ab initio from the part or portion considered being of a valid nature. However, it is important that with the severance and invalidation of some section or clause in a document, it will not affect the validity of the remaining sections or clauses. The Oxford Dictionary defines severability as a provision in a contract, statute or other legal document containing an exemption from one or more of its conditions and provisions. In the case of Dunkley v. Evans and Ainer, 1981, 3 All ER 285, CHD, it was held by Ormrod L.J. that where it is possible to sever an invalid part of an order, rule or regulation made in exercise of a power conferred by an Act of Parliament from a valid part of that order, rule or regulation, then, unless the invalid part is inextricably interconnected with the valid part, the court is entitled to set aside or disregard the invalid part, leaving the rest intact.